Good evening, everyone, and welcome to AJP's August webinar series on the topic of roadside utility boxes and their contested jurisdiction. My name is Amanda, and I'll be moderating the session. There will be a question and answer session at the end of the talk, so do leave your questions in the chat box, or if you prefer, ask them live later. Without further ado, I'd like to invite Alvin Sigar to present. The floor is yours, Sigar.
Thank you, Amanda. Let me just introduce myself. My name is Mr. Sigar Achor from Alvin Sigar Partners. I'm a lawyer here for a good time already. I think today I'll just give you just a brief introduction from a recent High Court development in Malacca this year. And I think I'll just pull up my slides for the time being. Amanda, I think I have to get the permission. Sharing. Yes, so I think today the discussion will be about the contested jurisdiction of utility boxes. Utility boxes, I think many of us will be familiar with this particular installation that we will see on the roadsides. I have some pictures in the slides later on, but this is something of a contested jurisdiction due to the fact that we have over the past 2 years, we've been seeing some actions from certain state governments to try to innovate certain laws to take hold or to impose certain state charges upon what are electricity installations. And so this webinar today would just be more of an introduction to what we have as a firm been dealing with in the past 2 years or so. So if I could just pull up my slides, still can't pull up my slides. Okay, all right, one moment. Okay. All right. All right, Amanda, do we have the slides up?
Yes, the slides up.
Yeah, all right. So I think we'll just start this webinar. Sorry for the technical issues. So I thank you for everybody for joining us this evening. Thank you for giving us your time. Today, our slide presentation will be on roadside utility boxes and their contested jurisdiction. So what is a utility box? Roadside utility box. But before we go into that, we will just talk about the background of the case, and then we'll just go to the contested jurisdiction and have a short discussion on the nature of the disputes that we've been facing. So as a short background, what are roadside utility boxes? As you can see from the pictures, these are metal cabinets, commonly found in urban centers. You can see them in residential areas, and most commonly you will see them at street junctions, along state roads or municipal roads. They are mostly concentrated in townships, urban areas, industrial areas, and commercial areas. These are usually found on municipal paved roads, pedestrian walkways, and also on roadsides. And what they are installation for components that are part and parcel of larger urban infrastructure systems, and they act as the supporting system for essential services such as electricity supply and distribution. You have telecommunications and also internet services. Now, the purposes and the types of utility boxes varies according to who owns the box and what are the services being used or being provided for. And this really depends on which public utility company or federal licensee operating the box. So these are just some examples of utility boxes that you can find across townships. You have the local council feeder pillar box, which you will see very obviously from the markings. And you also have the Naga National's TNB's feeder pillar boxes. You have telecom high-speed broadband boxes, HSBB boxes. And you also have link boxes. Now, all these plays very distinct roles. So feeder pillars are are actually installation for underground cables, and this is part of a distribution system. TM also has its own HSBB boxes that is in charge of, that helps facilitate the internet networkings in municipal area. And you also have link boxes which connects underground supply lines and join them together. So these are just some examples of utility boxes. And for examples of urban infrastructure systems underpinning those boxes, this is just two examples. You have telecoms communication networks, and also you have Tenaga Nasional's electricity supply infrastructure. Now you can see that the utility boxes are placed as a component to these complex and larger infrastructure systems. So they do play a very vital public role in much of our daily lives. And I think that's something that is good to know. And what is also good to know is also how these utility boxes come into existence. These utility boxes are installed alongside urban development, more commonly. So often you'll see that these are boxes that would be identified in a development plan. Depending on the developers, they would usually have to have these boxes built into their development plans to allow for essential services to be provided to the developments. And that most of the time, it's also a prerequisite by the local authorities of planning permissions. So the laws that govern this process of approval of development controls is known as the development control process. And this is covered by three principal federal laws, mainly Town Country Planning Act, the Local Government Act, Street Drainage and Building Act, and also the regulations made thereunder, such as the Uniform Building Bylaws. Now, how it works is that plans are submitted by developers to a state planning committee, and this will be approved by an internal committee, and it will be implemented and given final approval to the local planning authorities for issuance of planning permissions, development orders. And as you can see, the main head or the person who gives the approval for the state side would be usually the Director of Bagian Corridor Infrastructure, a state entity. And the local planning authority would be the local municipal council, which would normally be chaired by the Yang Dipertua or the mayor. So that is, and also once the development plans, which includes utility box amongst other installations, are approved, what the final decision is given by the local planning authority is in the form of a planning permission. Now this allows certain developments to legally commence, and that is how utility boxes are erected in urban centers. So that's just a brief understanding of the ins and outs of utility boxes in our country. Now, we come to the dispute regarding the utility boxes in Malaysia. Now, in 2018, what happened was that the state government of Malacca introduced an amendment to the Malacca Land Code. And this was the introduction of a state charge known as utility box charges. And what was amended under this amendment was Rule 19. So this introduced utility box charges over utility box residing and occupying state land, reserved land, and mining land. An applicant who is required to apply will have to pay annual charge of 500 ringgit per box each year for each and every utility box that are currently residing over state, mining, or reserve land. This is in 2018. Now, in 2019, before that, the new amendment also introduced a definition of what constitutes a utility box. So the definition is fairly wide. This is the first ever definition of utility box under law. So this is of particular interest when it comes to defining a subject matter that is a utility box. So what was defined as utility box under the amendment is that it includes, so it's an inclusive definition, any electrical enclosure containing any electrical or electronic equipments and facilities, including any equipment in any written law relating to electricity supply industry and any facilities defined in any written law relating to the convergence of communications and multimedia industry. What essentially this definition allows is a very broad reach of what constitutes state authority powers. So as you can rightly observe that in the definition alone, it has outreach to the electricity supply industry. It has also outreach to what is communications industry. And this all this is enclosed and packed in a state enactment. So all this came to a head in the same year under legal action or a judicial review brought by Tenaga Nasional Berhad. This was an action for reviewing of a decision against the Pengarah Tanah Galian and also the Kerajaan Negeri Melaka, the state in short. What happened was in 2019, TNB received two letters that construes a decision to have that particular charge, that state utility box charge, to be imposed on Melaka, on TNB in Melaka. That letter construed that TNB did not possess prerequisite state authority consent for its utility box to occupy state land and reserve land in Melaka for each and every utility boxes. It didn't define how many, it didn't identify what utility boxes are. This was imposition on TNB. Now, with that, it construed TNB, because saying that you don't have state authority consent, it construes TNB to be an unlawful occupant, an illegal occupant, a squatter, simpliciter. And where you do not have the rightful authority to occupy state land, the penalty for that is under section 42 of the section 425 of the National Land Code. Now, this comes with a fine of not exceeding 500,000 ringgit or imprisonment of not more than 5 years or both. So fairly serious and severe consequences if TNB were not to comply to that decisions. Now, the solution that was proposed in the decision was that TNB must now, because its occupation of its utility box were occupying illegally, it has to rectify its occupation by applying for temporary occupation licenses under Section 65 of the National Land Code, paying the utility box charges of 500 ringgit per box, not per square meter, but per box annually. And this was the main gripe of the state's decision. Now, upon receiving these letters, this decision, TNB decided to judicially review the state's enforcement of those decisions. TNB contested that the occupation was legal by federal laws, and that the utility box as a subject matter fell under federal government jurisdiction. However, the contentions that were coming from the state was that the state consent firstly must be expressed. TNB nowhere in its record showed that under the title, under any of the records of state, showed that TNB had expressed consent for each and every feeder pillar in the state of Melaka. Now, this matter of how many feeder pillars or link boxes or utility boxes in Melaka that was owned by TNB was never quantified. So this was never at all quantified by the state, but they were saying that you must have express consent for each and every one of these boxes, and that it had the right, because these were state lands, these were reserve lands that were vested in the state government, and therefore such charges were rightfully imposed because this was state government jurisdiction. Now, this was the main argument that was raised by both sides. Now, how is it a contested jurisdiction? I think it will be clear for many of you that just by the definition of what constitutes a utility box, just from the definition alone, as I've mentioned earlier, it attempts to outreach certain jurisdictions, for example, electricity, and also it outreach to communications. But for this matter, when it concerned Tenaga Nasional, it was actually going towards federal jurisdiction. So federal jurisdiction is provided for under the Federal Constitution, 9th Schedule, List 1. Section 11C provides for electricity to be the sole jurisdiction of the federal government. Now, our argument here was that utility boxes were part of larger infrastructure developments or infrastructures that were vital for supply and distribution of electricity supply in any administrative areas of Malacca. And utility box are vital to that. So that it has to be federal government jurisdiction. Moreover, we argued that in imposing a state charge of 500 ringgit per box, that was going into the jurisdiction of finance, because under Section 7 of List 1, sub-provision H and I, finance includes taxation. It includes fees that are related to federal law. Now, when the state is enforcing a TOL, temporary occupation license, under Section 65, with a charge of 500 ringgit per box, this was something that can be construed as a tax. It can be construed as a charge that is under federal law. And where this charge is introduced by state enactment, there is a provision under the federal constitution stating that any laws, any rules, any land rules that introduces a new charge or charges under land rules, that charge or levy must go through what is known as the National Land Council. The National Land Council is a federal body. It must direct any imposition of levies or charges that has to do with land. So that was not done. And therefore, to impose a state charge of 500 ringgit without going through the National Land Council is an outreach, an outstretched reach, and a usurpation of federal government jurisdiction. And lastly, and more interestingly, is that the federal constitution provides for an express exclusion for state revenues. And this is one of a very interesting point under our federal constitution. It is in the 10th schedule of the federal constitution, section 3. It provides an express exclusion for revenues to state where the revenues are derived from licenses that are in connection with electricity installations. Now, one does not have to wander too far to understand that feeder pillars and link boxes of Tenaga Nasional are integral, if not connected to larger supplies, larger infrastructures of electricity supply and distribution. So by that logic, there can be no imposition of state charges, licenses, or levies that extracts revenue from this type of installation. With just these 3 points, it is very clear, or rather there is a very good indication that link boxes, the utility boxes that are owned by TNB in Malacca, falls under federal jurisdiction. The argument opposite was that, contrary to all that, rather that because the utility boxes are residing on land, now the state jurisdiction under List 2 of the Federal Constitution provides that land vests absolutely with the state authority. And therefore, anything that has to do with land, any dealings that have to do with land, solely and absolutely vests with the state. And therefore, if you do not have the express consent of the state, you are illegally occupying that land, reserve land or otherwise. and penal action can be taken under Section 425 of the National Land Code. Now, it's a very simple proposition, but that's the state's construction of the facts. But we've raised that in addition to these two jurisdictions, you also have the third jurisdiction that's provided under federal law, that is the concurrent jurisdiction. Now, this is under List 3. List 3 provides that, but just before that, concurrent jurisdiction is essentially a power sharing between state and federal government. Town and country planning is provided under Section 5 of List 3. As I've mentioned earlier, there is a power sharing between the in approving development orders under the Town and Country Planning Act. You have at one stage approvals from the state authority, state planning committee, and this is usually headed by the Pengarah Bahagian Corridor Infrastructure. This will be approvals given on behalf of the State Secretary under the office of the relevant Chief Minister of the state. And after that approval is obtained for that development order containing the utility box, that then passes down to local authorities for final approval for planning permissions. Under that power sharing agreement, there is actually both federal government and state government at play. And this legalizes what the state is condemning to be illegal for the occupation of utility box in Melaka. And one more point that I didn't mention in the slides here is actually there was an interesting argument that was raised by us in our arguments here, is that the main contention of the state was that our utility boxes were directly in occupation of state land. But the state considered that the land that the pillars and link boxes were on were actually road reserves. Now, this is a particularly interesting point because under the concurrent jurisdiction and the three main federal acts that we've just mentioned earlier in the slides, it creates a new local authority jurisdiction, a jurisdiction for municipalities. For example, the Town and Country Planning Act, the Street Building Drainage Act, and also the Local Government Act allows local governments to powers over streets, allows powers to do undertaking works on streets, pedestrian walkways, which the state is contending our utility boxes to be situated on. By that logic, it was an argument that we've raised that we are not on state land. We are on municipal pedestrian walkways, streets. So we are not directly occupying state land. Instead, this is a separate and distinct jurisdiction created by the concurrent list of the federal constitution that solely vests in the local government, not the state. And mind you, local government is under a federal ministry, the Ministry of Local Government and Housing and Local Government. So by that logic, and it's an interesting argument, we are not trespassing on state land. We are on municipal land, or rather municipal streets. So as you can see from all this, it is abundantly clear that this was an area ripe with contested jurisdiction. Now, it begs the question, when we've put up all these different subject matters under the federal constitution, which is the prevailing jurisdiction? So now it is a good time to turn to what was decided. How did the courts unravel this contested jurisdiction amongst utility boxes? So on 18th of May this year, Yang Arif Anselm Charles Fernandez gave a fairly comprehensive decision. And the main ratio decidendi that we would be highlighting is in relation to the state's assertion that we are, number one, unlawful occupants of the state, our utility boxes were unlawfully occupying state land and reserve land. Now, what Yang Arif, his lordship, mentioned and held was that the TNB's utility boxes were sanctioned under federal government jurisdiction. Now, the federal acts that we just discussed on sanction the occupation of TNB's utility boxes on subject lands, or albeit them being the state lands and reserve land. Now, the federal acts that accorded TNB these rights were the following acts that we've just discussed, and there were other regulations that were involved as well. All this cumulatively allowed TNB legal authority to occupy that land. There's more to the details, but we'll just go through this on the main points that Young Arif was mentioning. By this logic alone, this would negate the contention that there was trespass, that TNB was actually an unlawful squatter over state land that today is state land. This was also when state charges are imposed on utility installations and even give the inclination that there is a risk of penal action under Section 425 to evict and to dismantle these boxes. That would be contrary to why those utility boxes were there in the first place. Obviously, when it was decided that certain boxes has to be in this particular area under the development plans, it has to serve a larger purpose. And that larger purpose is the distribution and supply of electricity from the infrastructure development, supply infrastructure system of TNB in the first place. So imposing contrary decisions to undermine that that objective is contrary to the very spirit of this federal acts, which allowed those utility boxes to be placed there in the first place. And also in closing this particular judgment for this point was that it is strike law, it's strike public law, that when you have a state legislation that runs contrary to the principles or defeats the objects of a federal law, then Article 75 comes into play of the Federal Constitution. And it says that where there is a inconsistency between state and federal law, the federal law will always prevail. So as such, based on these reasonings, TNB's box number one, we are not seen as an unlawful occupant. We are validly under federal government jurisdiction, and we are not liable to apply for temporary occupation to legalize what is already legal under federal law. So that was the first point that Young Arif made. Now, moving to the second point, was that when the state imposed such a decision on TNB, there was a finding made that the two letters were made without any prior consultation with TNB. And this was when in 2018, it was gazetted as amended provision to the enactment, the land enactment. Nothing was done. There was no negotiation. There was no preliminary consultation, nothing of the sort. That was in 2018. And 2019, it was a direct imposition on TNB. This state of affairs was seen by His Lordship to be affecting the permanence of essential electricity supply. And when this is done without the consultation of the relevant parties, here being TNB, the expertise and the experts in that particular industry who owns those installation, that would be contrary to public interest. How he derived that reasoning is, firstly, electricity is a necessity, and this is provided for under the federal list. It is federal government jurisdiction, and it's also part of the right to life under our constitution. And when such imposition that imposes a 500 ringgit charge to TNB, this will definitely increase, or this would likely increase over time. There's nothing to stop the state from increasing it or even denying the application for TOL. And if this were the case, wouldn't that would definitely and ultimately burden the public. And if this were to be done without any control from the state. So if the state were to just exercise land rights flagrantly, it would be against public policy. It would be unreasonable for not only the applicants but also the consumers to electricity, when first of all they were not consulted at all. So natural justice rights are infringed, and ultimately is because if the permanency of these installations are given to the mercies of state authorities, this would put all parties in very precarious position. And this was of particular note because the chart was seen, and this was clearly shown in the Hansard reports for the State Assembly. This chart was intended to be a form of revenue for the state. So that could be seen as a real danger. And for that reason, Yang Arif, his lordship, was of the opinion that it would act against public policy, in addition with the fact that utility boxes that they assert to be unlawful were within federal government jurisdiction. So what happened was the High Court agreed with the applicants and granted orders for certiorari, that is a quashing order, and also declared the decision by the state to be unconscionable, unreasonable, irrational, illegal, and also unduly oppressive, and also infringement of the applicants' TNB's natural justice, rights to natural justice. And as such, TNB was granted prohibition orders to avoid any action by the state to remove feeder pillars from the state, to interfere with works on TNB in installing feeder pillars, and also to stop any likely enforcement actions that would result from this case. So those two main lines of reasoning from Yang Arif were the main points in allowing TNB and setting the tone and also the direction of law in regards to electricity installations in a state. So I believe that the main takeaway from this case is that where executive powers from the state government are enforced in contravention, that are enforced inconsistently with federal laws, such action will be liable if not subjected to judicial review, and they would be quashed if they are seen in contravention. And secondly, the state is not entitled to countermand legal occupation where it is duly and previously authorized by federal laws. This is a very specialized area that has been sanctioned and blessed by the federal constitution. So federal laws will prevail in the end of the day. And lastly, where state laws are found to be inconsistent with federal laws, Article 75 of the federal constitution clearly states that federal law shall prevail, the latter shall prevail. So I believe those are the three main takeaways, and that is how this contested jurisdiction of this case was resolved by the High Court Judge Yang Arif Wan and Salam. So I believe this is an interesting case. I think this would be a good development of law that develops what is legal occupation and the primacy of federal laws and federal jurisdiction of the federal government. So I think that is all from me. I hope everybody has taken something home today and maybe you've learned something more on the electricity laws today. If you have any question, you can ask, but I'll hand the time over to Amanda now for Q&As.
Thank you, Sigar, for that very insightful session. We now open the floor to questions and answers. Any questions? You can either drop it in the chat box or ask it live.
Hi, Amanda. Sigar Rusman here.
Hi, Rusman. How are you?
I'm doing great. How are you? I have one question regarding this issue. You did mention that this Malacca Land Code was imposed not only to TNB but to other utilities as well in Malacca. So let's say in this case, TNB apply for the judicial review, and the decision was in favor to TNB. Will it be impact to the other utilities as well, who has paid the state government on the imposition of the charges?
Thank you, Encik Rusman, for the question. So for us, we are privy to the fact that this has been imposed on TNB. We are not sure whether this has been imposed on other utilities companies, but it was the intention of the imposition was revealed in the legal process that they were trying to get utility companies, but we are not sure, or it was not disclosed exactly which utility companies. However, your second part of the question is in relation to whether this particular decision can be translated to subsequent decisions. Most certainly it can. The principle is universal. It is applicable insofar as the rights that you have are already sanctioned under federal laws. For example, the electricity supply laws, which allows for legal entry into the land, and also whether your installations have already gone through the concurrent jurisdiction process of the development control processes, where you will see that the local government has already given sanction over your particular installation. So this works hand in hand, and that comes to the principle that federal law will always prevail. Federal law is the primary law where it has really demarcated the subject matter. For example, here being utility boxes. But again, utility boxes are very wide in definition. So I'm not surprised that it will be applicable in other cases as well, Encik Rusman.
Okay, thank you, Sigar.
No problem, Encik Rusman. Any other questions?
Is there any more questions? All right, so if that's the case, that's the end of the webinar. Thank you again, Sigar, for that very informative session. And thank you everyone for joining us and supporting AJP's webinar initiative. We look forward to seeing all of you in the coming webinars. Take care and stay safe. Bye.